Good evening. Happy Thursday. There's this video someone wanted me to review from Maddie Madness. And I'm not going to play it for you. I'll put a link to it in the description. If you really want to watch it, you certainly can. She needs your clicks and views because even though she is a highly successful paralegal, she's still just a paralegal. She's very proud of being a paralegal. She asserts the fact that she's a paralegal to try to explain to the clerk that she knows what she's talking about. And then she goes on and on and on and on and on and on about Tribune Company versus Cannella. On and on and on. Anyway, I don't want to make this too long. What you see here on screen is a piece of paper that the clerk, who's apparently a supervisor, has handed Maddie. And on it you see Siegmeister versus Johnson, which is quoting the Tribune Company versus Cannella. And the heading there is unjustified delay. You can see delay right there. Somewhere in there, if you find it just right, it says something about unjustified delay. Anyway, I won't bore you trying to find it. You can just take me at my word. It says unjustified delay, and it's quoting Siegmeister versus Johnson. Now, this is the Tribune Company versus Cannella. Now, Maddie's two main assertions is that number one, that there are no redactions that the clerk can do, that the custodian of the records can do, that she has to immediately, without any delay, hand over the documents so that Maddie can photograph them without having a chance to inspect them, to redact them, to assert, confidentiality on portions of them, or to determine if the entire file is or is not confidential. Well, and you can easily dispense with that, despite Maddie's many protestations that Tribune versus Cannella holds that there are no redactions and that the records have to be turned over immediately. In fact, Tribune versus Cannella says the only delay permitted by the Act is the limited reasonable time allowed the custodian to retrieve the record and delete those portions of the record the custodian asserts are exempt. So Maddie's own case undermines her two premises. It allows delay, first of all. It's the only delay it allows, but it allows delay, and that delay is specifically to retrieve the record. Of course, you'd have to review the record to know what you're going to delete, and then delete those portions of the record that the custodian asserts are exempt, because there are exemptions. There are general exemptions, and in here there are exemptions for agency personnel. Here we go. I saw a social security number. Got to be in the right spot. Close. I thought I saw social security. Yeah, here we go. Agency personnel information. Social security numbers. Medical information. Personally identifying information of a dependent child. There's just all sorts of home addresses, telephone numbers, dates of birth, blah, blah, blah. So some of these do go to undercover individuals. Yeah, undercover personnel. So there are things that I don't know who Maddie's file she is trying to get. And yes, I know Maddie is a biological male, and I just don't care. I should care. I probably should care, because we're experiencing all sorts of bad things as a society because people like me don't care. So I probably should care. I should care, but I just can't really bring myself to care. So anyway, what about this Siegmeister versus Johnson? Siegmeister versus Johnson. I'll just tell you the facts of Siegmeister versus Johnson. The attorney for Johnson requested the file for a case that was no longer active involving Mr. Johnson. So the attorney who had the file, the state attorney who had the file, sent it to then state attorney Robert L. Skip Jarvis. It took about a week for the file to get to Skip Jarvis, about a week for Skip Jarvis to review it. And then there was some sort of a snafu, I believe, in mailing it out, and it took like an extra week to get mailed out. But the holding is that violations of the Public Records Act encompass not only affirmative refusal to produce records, but unjustified delay in producing them. Now, if you'll notice, the gal in the video did not refuse to produce them. She said that, she just needed time. But a delay does not in and of itself create liability under section 119.12. Reasonable delay is allowed. Once a request to inspect public record is made, records custodians must respond promptly and in good faith, determining, for instance, if they possess the records, retrieving the records, assessing whether exemptions apply, deleting those portions of the record believed to be exempt, notifying the requester, and making the non-exempt records available. Turning to this case, we agree with the trial court that the 2-week period it took for a letter to be delivered from State Attorney Jarvis in response to Mr. Carson's request did not, by itself, breach the requirement to respond promptly and in good faith. The evidence indicated that only 1 week passed from the day Mr. Carson requested to inspect and copy the state attorney's file in Lake City to the day State Attorney Jarvis approved the request. So maybe I added a week in there. So 1 week from the day that he requested it to the day that Jarvis approved it. During that week, the relevant file was sent from the Assistant State Attorney in Lake City to the State Attorney's main office in Live Oak. State Attorney Jarvis then had to review the file for exemptions. The ASA couldn't have, for instance, simply handed over the records on the spot when Mr. Carson requested them in Lake City. The Act and official policy required that it be reviewed for exempt information by the public records custodian, who was also responsible for supervising the record inspection and copying process. Within a week of receiving the request, State Attorney Jarvis drafted a letter on February 2nd, 2011, approving Mr. Carson's request and making the records available to him. So 2 weeks have passed. After drafting the approved letter, an administrative snafu or postal service delay caused the approval letter's delivery to be delayed for a few days. Mr. Carson didn't receive the approval letter in his mailbox until 5 business days after State Attorney Jarvis drafted it on February 9th. So mailed out on February 2nd, 7 calendar days later. So we have a total of 3 weeks. These circumstances don't violate the Public Records Act. The Act demands prompt attention and a reasonable response time, not the quickest possible response. A few business days delay in delivery of mail is unremarkable. There's no indication here that State Attorney Jarvis intentionally or unjustifiably delayed responding for these days. That's what you're looking for. You're looking for intentional or unjustifiable delay. And I could go on. But the long and the short of it is that the clerk handed Maddie the correct legal citations that correctly interpreted Tribune versus Cannella, and Maddie was too arrogant, too cocksure, too puffed up with her paralegal status to take a few moments to actually read the citations, and instead just bloviated about Tribune Company versus Cannella, just like a sovereign citizen would. Anyway, so there you go. Maddie's wrong again. Thanks for watching. Have a great day.